Hey guys, welcome to this video. My name is John Watts, and the question we'll look at today has to do with foreclosures and a default letter. And so the way I've worded this, just so hopefully it'll make good sense, is if you've been non-judicially foreclosed, and we'll define that next, and you've received a defective default letter, then you may have the right to undo that foreclosure. Sometimes we call that make a foreclosure void, like it never happened. Or you can sue for damages. So let's define a few terms. Judicial foreclosure is where a court decides whether the foreclosure is proper or not, or will actually happen. So Florida is a great example of this. In Florida, if a mortgage company wants to foreclose on you, they sue you, they serve you with the lawsuit, you have time to respond. If you win the lawsuit, there's no foreclosure. If you lose the lawsuit, that means there's a foreclosure. I'm not talking about judicial foreclosures. Here I'm talking about non-judicial foreclosures. That's where there's no court that's involved. And Alabama is an example of this. So everything is done kind of privately, although there is some newspaper advertisement, but it's really just between the mortgage company and the homeowner, the consumer. No judge gets involved in it. That's what I'm talking about here. So when we talk about a default letter, we're talking about something that's sent under paragraph 22 of the mortgage. Now, there are different mortgages. Sometimes it's paragraph 21. I've seen it be paragraph 17. But the point is, it will be a paragraph that talks about what happens when you're in default. What does the mortgage company have to do in order to accelerate the loan, make it all due at once, and then ultimately do a non-judicial foreclosure. And we'll be going through some cases in other videos, and so you can see the exact language here. But for purpose of this video, so it's not so long, I just want to describe it. So when we talk about a default letter, sometimes it's called a breach letter. So Bank of America a lot of times calls it the breach letter. Sometimes it's called the notice of default or intent to default. And the idea is it's something that tells you, hey, you've messed up. You breached the mortgage agreement, the note. You've defaulted. Here's your notice of the default. Here's the notice of intent to accelerate. Again, different companies call it different things, but it's the idea that you're in default and we're alerting you to this because we're about to go down the path toward foreclosure. So in Alabama, here's the sequence. And in most non-judicial states, it'll be similar to this. So there's a default. In other words, I don't pay my mortgage. I don't keep my insurance. Whatever the case might be, where I violate a rule or a requirement in the note being the debt, or the mortgage, which is the security that ties the debt to the dirt, ties the debt to the property. So then I get this default letter or notice of breach, or notice of intent to accelerate, notice of intent to declare default, breach letter, whatever the mortgage company, I'm just going to call it the default letter. And then they have to give me a deadline that's at least 30 days away. I don't cure the default. And then they accelerate the loan, so it's all due now. And then they advertise it, and then they actually foreclose. So that's the sequence in Alabama. Here's the critical thing. Every step, so go back here, all these steps are dependent on the step before it being done properly. So if we go, hey, can they accelerate, but they didn't give me a proper default letter? Well, no, because everything is built one step at a time. So let me go back to this. Again, just a reminder, we're looking for, is there a flaw or an error in that chain? And in this video, we're focusing in on the default letter. So if there's a defective default letter, breach, notice of intent, whatever you want to call it, if there's a defective letter, then the foreclosure may be no good. Now, it actually happened, okay? I mean, the property is gone as far as the ownership, the bank or whoever bought that. But I'm saying legally, it may be no good. In other words, you may can have it undone, or you may can sue for breach of contract, or even do both. And there are other claims that may be able to sue under Fair Debt Collection Practices Act. There may be credit reporting issues involved. But the point is, you may have some options even after a non-judicial foreclosure if you received a defective default letter. So, what are the requirements? Again, this is based on Alabama law where I practice, but I think most states are going to have a similar paragraph 22 if they're doing a non-judicial foreclosure. Certainly check in your state. So basically it's going to say, hey, look, you're in default. You didn't pay your mortgage, or you didn't keep your insurance up, or whatever it might be. And then the second thing they have to tell you is, here's how you cure the default. So, 95% of the time we're talking about the mortgage payment hasn't been paid. So they say, you're in default, not paying your mortgage. You can cure that by paying $8,743.17, and that will cure it. But then the third thing is they have to tell you when your deadline is. So it has to be a date certain of time where they go, this is your deadline. And it has to be at least 30 days from the date that you receive the letter. And so let's say that you get the letter on September 1st, and it says you've got till October the 10th to pay the $8,000 whatever dollars. Okay. Well, then it's got to warn you if you don't cure the default. In other words, you do not pay that money, or you do not get your insurance, or pay your property taxes, or whatever they say the default is, then we, the mortgage company, may foreclose. And before we'd foreclose, we would accelerate the loan. Well, then there's two other things that have to be told to you. And that is, and these contemplate if the default is not cured. So they have to tell you, even after we accelerate the loan, so you had 28 years left on your mortgage, boom, it's all due right now. Even after they say that, you can still reinstate your mortgage and not have to pay the entire amount. You basically pay whatever you're behind on. And they have to tell you, you can bring a court action to challenge the default or the acceleration or the foreclosure itself, or you can do all those things. So remember, this is in a non-judicial foreclosure. So my friends who practice in Florida and do foreclosure defense work like we do in Alabama, it's almost like they can't understand. Like, what do you mean there's no court involved? I'm like, there's no court involved unless we, the consumer, file the suit first. And we have the authority under paragraph 22. And so that default letter has to tell us of our rights. So here's some examples from cases that there's either been a foreclosure threatened, or in almost all of these, there's actually been a foreclosure, and we've been able to undo that foreclosure and or get money damages for our client because of the defective default letter. So you might get a default letter that's dated September 1st, and it says you have to pay $8,743 by September 28th. Well, wait a minute. That's not 30 days. I have to be given 30 days. And they can't go, well, I mean, it's pretty close. You weren't going to pay it anyway. No, it doesn't matter. Because mortgage company, you have now breached the contract by refusing to give me the full 30 days, at least 30 days, that paragraph 22 requires. So that would make the foreclosure something that we could go to the court. If we're dealing with this after foreclosure, we go to the court and say, void that foreclosure. Declare that that foreclosure is no good. It never happened. Well, what would be something else? Well, what if they do not advise you that you have the ability to reinstate the mortgage even after acceleration? Well, that would violate paragraph 22. It would make it a defective default letter. If the default letter is defective, then the acceleration is defective. Because first you have to have the default letter, then you have to have the acceleration letter, and then you have to have the foreclosure advertisement, and then the foreclosure. Well, it's sort of like a foundation. You pull the foundation out, the whole thing collapses. Well, what about if they don't tell you you have the right to bring a court action? So let me tell you what a lot of times they'll do. They'll say, you have the right to assert defenses in the foreclosure proceeding. Well, We don't have foreclosure proceedings in Alabama. It's non-judicial. That's language that would be appropriate in Florida, but not in Alabama. Okay, and we've even had this with companies where they say, you may have the right to bring a court action. What do you mean I may have the right? The mortgage says, I must be told under paragraph 2, I must be told I do have the right. And now you're saying you may have the right. And so the argument we've made before is, think about the Miranda warning, right? You've seen the cop shows. You get arrested and the police officer is supposed to say something to the effect that you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney. Can't afford one. One will be provided. We'll just substitute in the word may. You may have the right to remain silent. You may have the right to an attorney. If you can't afford one, then one may be. See where we're going with that? So the point is, a defective paragraph 22 letter can make the whole thing fall apart. And so think of the implications of that. There's been a foreclosure. Well, that was an illegal foreclosure. That means they breached the contract. If they're a debt collector, they almost certainly violated the Fair Debt Collection Practices Act. What about if they put on my credit report that I've been foreclosed? And I dispute that and go, they had no right to foreclose. And they verify that with the credit bureaus. And then a judge says the foreclosure is void. It never happened. Well, isn't that a problem under the Fair Credit Reporting Act for Bank of America or Wells Fargo, whoever it may be? So it's a very, very powerful concept to study and look at that paragraph 22 letter, that default letter, notice of intent letter, breach letter. So here's what I would suggest to you. Hopefully you have that letter. And sometimes there's a whole sequence of these default letters. Really what we're looking at is the last one, because that's what the foreclosure is built on. And so if you have that letter, definitely pull it out. Pull out your mortgage. Find the paragraph 22, 21, wherever it is. See if it has those 6 requirements that I've identified. And then compare that with your letter. Does it match? If it does, well, then that would be a proper letter. But if it does not, then you may have some opportunities. Well, what if you don't have your mortgage? Well, go get your mortgage. Go to probate court. Get it. What if you don't have the default letter? If you're within a year of the foreclosure, you can send a RESPA letter, what's called a request for information letter, to the mortgage company and identify yourself, identify the loan, identify the property address, and say, I want copies of all notices sent under the mortgage to me, including, but not limited to, but definitely including the default letters or the notice of intent to accelerate or whatever they're called there. And they'll have to send those to you. If they don't, that violates the law. Okay. So if you're in Alabama and you think you might have this situation and you want some help, just want to talk about it, want me to look at things, go to contactjohnwatts.com. That'll take you directly to our contact page on our website. You can send me a message. I'll look at that. And then send me those documents. If you've got the default letter, send that to me. If you've got your mortgage, send that to me. And let me look at that situation. Now, if you're in another state that's non-judicial, get with the lawyer there. And if they want to get me involved in the case or you want them to get me involved, I'm always happy to talk with lawyers about that and folks in other states. But, we have to look at what exactly the rules are, what your mortgage says in your particular state. So anyway, thanks for watching this. I hope that this is helpful to you. And if you are facing a foreclosure, very scary thing, remember you've got that right, if your mortgage says you do, to bring a court action. If you've already been foreclosed, it may not be too late. But you got to hustle, got to look at that mortgage, got to look at that default letter. And if we can help you in any way, certainly let us know. And thanks for watching this video. Bye-bye.